Okay, so we have donuts if everyone.
They're fresh this morning.
Oh, well, that's good. Let's finish our discussion from the other day. We have a few other items to discuss, but I'm wondering if you gave thought to the question I left you with in section 6 is, how do you avoid something similar happening to you that Ayud visited upon his lawyer? I'm wondering if you gave any thought to how you'd try to keep that from happening to you. And I think maybe sometimes, even for me, it's easier to sit here and say, oh, I'll be able to avoid it. But you got to remember, you're also trying to hustle clients in business, and you need to pay the bills. So to the extent that you put every one of your clients through the third degree and make them think you don't trust them at all, that's not going to build a very healthy practice. Conversely, if you get caught in things like this, when you think you're doing, even if assuming you're doing the right thing, you get swept up in a client's fraud, reflects pretty poorly on you. Either you're a rube or you're a cheat as well. So how do you avoid that? Now, how would you intend to avoid it?
Pray.
Well, but praying's only going to get you so far. Really, right? I mean, I tend to be kind of cynical, but every now and then, not even every now and then, more often than not, somewhere along the way, I get surprised at what I thought was the case. I had one time I was on the right side of it. It took a while to prove it, but by the time we were done, there was no doubt in my mind the other attorney, and specifically his client, had fabricated, backdated, and invented items in his invention diary journal simply to be able to try and cheat my client out of the money. It took a while to be able to prove it, but there was no doubt at some point that I made the attorney aware through the course of the discovery that his client clearly had to be offering, and therefore him as well, a key piece of what had clearly been at that point, and I would be able to prove it had the case gone to trial, falsified evidence, and the key piece really. So I actually I blame him then too, because I don't trust him either, right? If you're at some point you come to realize I got the cheat, and so I'm wondering what you do. How do you just try and avoid it? I mean, okay, we can talk about it. I'll dot my I's, I'll cross my T's. To some extent, this fabrication then, and not just to some extent, it's referenced on the second page of the appellate decision. This fabrication, among other things, costs him the case, right? So in essence, him thinking he was clever than anyone else in the game cost him his case, and so maybe that's a lesson for us to be able to work with and tell our clients is that, I've got to have all the information that so I can work with you and properly prepare your case. And if I suspect that information isn't quite as it seems, then what?
Jamie,
Go ahead.
I think that's the best way to go about it, is to sit down with your client and be like, listen, for you to get the most out of me and for you to get the best result that you think you can get, you got to be completely upfront and honest with me. Because if there's anything you're not going to tell me, it's going to come out in the wash sooner or later. So you could tell me and get it on the table now, and we could deal with it and find a way around it or work through it, or it's going to come up and eventually bite us. And when it's too late, there's nothing we can do about it.
There's some lawyers who repress that they don't want to know everything. I don't want to know, because that ties my hands if I know potentially the truth. I'm not that guy. I'm Derek as well. I'd rather know and work around it. We can advise you of your rights. But there are people that will just tell me what it is, tell me your story, and I'll tell you what options we have.
Would it make any difference if it was civil or criminal in that case, do you think?
I don't really know. My guess is, and this is probably some of my own prejudice, and I think criminal defense attorneys will tell you otherwise. I mean, who's supposed to be the bad guy in the criminal law cases, right? That's the accused. He's all likelihood guilty or he wouldn't be here, right? No. But in civil suits, you know, sometimes they're both cheating. Sometimes, obviously, in criminal cases, they both are too. But at least in crim cases, we sort of have a better idea who's supposed to have the black hat on, even though that's not always true. In civil suits, could be that they're both cheating. And that's sort of the problem as well, is that, I mean, obviously they both have an incentive. Arguably, the government in a criminal case has less incentive to cheat, but I would bet if we had a few criminal defense lawyers in here, they would be making the argument that, and by the way, what they do make the argument is there is far less cheating in criminal cases than there are in civil cases.
I agree with that.
Huh?
I agree with that. I agree with that statement.
Why do you agree with that statement?
Because they're guilty. What do they have to lie about, really? No.
Well, they have to lie about keeping that butt out of jail. That's a pretty important incentive.
They'll tell you how strict, you know, I mean, if they do, majority of them anyway. Because you get appointed to them and you know what they did, you know what I mean?
I kind of back you up on that, but at the same token, you never get the whole story. You just don't.
You never get the whole story from anyone.
From anyone.
In any
It's
case.
sad, very sad. And
It's
it's
virtual.
The class will tell you exactly.
Point taken, but I still think
So I
that
think-
would be less.
So I'm thinking a criminal case versus a civil case, if I was practicing, I might be inclined, your original question, I might be inclined to not want to know all the details in a criminal case. Like I might say, just tell me your story, I'll put you on the stand, you know, and just take whatever the person gives you.
The problem with that, though, is the relevant facts that the defendant sees aren't necessarily the relevant facts that you might be able to work with.
Right.
So they'll tell you what they think you want to know, but meanwhile, they might be able to give you information that might actually be helpful.
Right, but then you
Well,
start
the
pulling
common will
out.
find something out that you don't know
Yeah,
about either.
you pull out what you need and only take what you want, and then like his preference was, his premise was, okay, that's all I need to try this case, shut the hell up. Whereas in a civil situation, where you got two businesses, let's say, right?
Mhm.
It's a very complicated fact pattern, both sides are probably lying, making up half the story made up, who knows, right? You gotta know, you might wanna ask more questions and get to more details to win. So you know, so I'm thinking that might be the difference between criminal and civil. That's just something I was thinking anyway.
Yeah. Okay, but so how do you avoid? Just work harder, review everything,
That's what-
never
I'm
stop
gonna stick with what I
looking,
said the other day, yes.
get more documents.
Yes.
And at some point, though, even with whatever you got to move off the dime, right?
Yes.
I mean, and that's the problem. And I guess, you know, you asked me what we would do. There has been one or two occasions over the years, not when I've been up here, but when we were in Boston, that if we had real doubts about the veracity of the story and were concerned that it could get us in trouble, we did suggest that there be a polygraph exam, even in a civil suit, to make sure that we could then provide it just maybe as a means of bringing the other side to the table. And in some cases, well, in both cases, that was sort of the end of the whole thing, because they didn't choose to provide the additional assurances that we needed. And that's the other thing about it. And this is what you have to figure out, if I feel that uncomfortable, then maybe I'm just not in, right? Let someone else worry about it.
Yeah, wouldn't you, I mean, this guy was so fraudulent, I mean, wouldn't you just withdraw? Like, once you realize the game's, I mean, he's making the attorney look like an idiot. Wouldn't you just withdraw?
Yeah, but see, the problem I'm trying to avoid, or trying to think about how, and work with you guys to see how you can avoid is, okay, so I withdraw, but my name was on that complaint. I'm the one that attached the phony document to the complaint.
Yeah.
And when we go back, I forget who the district court judge was, when we go back, whoever the district court judge was, he's going to remember that was me. And I'm the one that presented what is pretty much a fraudulent action. And like it or not, to some extent, we do become known by the clients that we represent. Right? He's a mob lawyer, right?
You can't erase what happened. You just gotta learn from it.
Well, but that's what I'm wondering. So, when looking at it, what have we learned? I mean, what do we do?
This particular case is a hard one because, you know, you say ask lots of good questions and keep probing, and then, you know, how your life experiences as a person should help you. You know, if you're a little bit more mature, you should be able to read people better face to face, let's say. But in this case, it'd be very, very difficult unless you've owned a gas station yourself and did a lot of these kinds of transactions to know that you should have asked, okay, who did the contract? How much did it cost you? You know, that's just so minutia that.
Well, but that's right. There's a lot of details here that we wouldn't be familiar with. I also think, and it's not just being older, I think there's a greater tendency you're going to be taken advantage of at the outset, right? Because after a while, you do get a feel for who you need to watch out for a little more, sort of that personality. But at first, obviously, you have a need for cases, and your radar isn't quite as tested, and you're probably a lot less cynical, saying, you know, listen, I really want to do good. I've got the good guy here. And really, you're fighting Mobil Oil Company. You're going to keep our gas under $4 a gallon. This is all good for us. The problem is he's not the white hat at all here. He's phonied up papers. He made you look bad. His intent really isn't to play by the rules, and now he sort of sucked you into not playing by the rules, assuming it's not intentionally. It just makes you look like you were complicit in it. And that's the problem I think you got to start to worry about. And at the same point, you can't have a big brick wall lined up in front of you for every client that comes in, because you've got bills to pay, you want to make money, you want to practice law, you want to help people. And so there's just a lot that goes into that mix when you say, how could I have seen him coming? I mean, he seems like a legitimate businessman, not only successful too. Not only has one, he wants to buy another. Seems like the simple one could argue, as I was trying to on his behalf, that the sympathies could lie in his favor. And what's the big deal to Mobil? But at the end of the day, we're hip deep in it, and we look like, I mean, not just look like, you attached. That was your choice, right? Because he doesn't dictate to you what your complaint looks like. That was your choice. You put the phony document and attached it to the complaint.
Could you, that phony document, could you have suggested, because there was another person that was part of the document said, you know, maybe it'd be better if you're questioning the veracity, and say, could I have him run an affidavit testing that this is true and correct?
Well, you know, and that's right. Maybe you guys did suggest, well, let's talk to him and see. And he says, oh, go to hell or whatever. But listen, again, you need injunctive relief. We've seen these cases now. It's going to be heard in some manner, whether that's on papers or in an actual evidentiary hearing. I got to talk to him. If he's not willing to cooperate, and that's where the flags start going up, right? I mean, I poo-pooed it when you said it. But if I call him and say, listen, I'd like to come over and talk to you. I want to talk about getting an affidavit, or I need to know what the facts are because you may have to testify. Whoa, I'm not going to testify. Right? Ding, ding, ding. Flags should start going off the more calls you make. Or, listen, I made 6 calls to him. He didn't call me back at all. Okay? Now, one can excuse, a lot of people have horrible phone etiquette. Okay, but this is going to be a pretty key witness of yours if we're trying to get an injunction. And so maybe that's it, is just do enough digging so that you have enough information that realistically you can, both your instincts and knowledge as a lawyer can help to take control and say, well, listen, I've got 3 pieces of support for it. I mean, the problem here is maybe he just relied on Aoud, and Aoud's a cheat. You know, if you get taken by 6 cheats, I'm not so sure that's your fault as much as it's, you better find a better class of people to be working with. But if you rely on one when you needed more evidence anyway and more information, maybe that is shame on you, because there are a lot of people in our business that will give you a limited amount of information so they can hear what they want to hear, and then say, my lawyer said it was okay to do this or that, and that's not what I ever said. But you're out there again in that situation as well. I like this case because I could see easily how it happens. I think we have to be very careful to make sure it doesn't happen, and I think you can practice as ethically and at a very high level as you'd like, and every now and then someone's going to do something like this to you anyway. But even more so, what makes it important then is to make sure on the 99.99% of the other cases that you've dotted your I's and crossed your T's, because sooner or later, you know, you drive enough miles, you're going to get into a car wreck. But if you get into a car wreck every month, that's, you need to be driving a different road, because that's as much on you as anything else. And let's look at the details of the case, because I think the case has a bunch of things going on. And the court talked about, obviously, the request for injunctive relief and using the standard. But I think no matter what he said here, and frankly, I think he's got some legal arguments. No matter what he said, because of what happened with the very first document he filed in this case, he didn't stand a snowball's chance in hell of winning. And that's the other thing to think about, is that, sometimes when we start pressuring the client for proof and additional information, Derek points out, they need to understand this is for their benefit. It's not necessarily that I doubt you. This is the challenge the other side legitimately is going to put us through. And if you can't prove your claim, and you can't prove your claim sufficiently, then we ought to know now, so that you save an awful lot of money that it's going to take in the course of trying to get you injunctive relief and ultimately a judgment. Because I don't want you having paid me $50,000 or $100,000 and dissatisfied at the end of it simply because you can't establish your claims and never were going to be able to. And that's the other part of it. I mean, there are ways to put this in context so that the individual understands, it's not that I doubt you. The question is, are we going to be able to satisfy both the court and the other side with respect to the merits of your claim? And, the fact is, if the case at the end of the day comes down to a he said, she said, that's a toss-up. And that's not necessarily a case that one should invest hundreds of thousands of dollars in getting ready with that unpredictable. If there's no proof to support any claims, again, ding, 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 things should start telling you that something just doesn't fit here. And there will be some where the client is absolutely correct, but there is no proof that support their claims. It's not that they're lying, that just the proof doesn't exist. You need to have a discussion with them that explains that this even still then may not make sense to throw good money after bad if the likelihood of success at the end of the day is that you cannot prove your claim, regardless of how forthright, sincere, or honest you find that person to be. Look a little harder to find the evidence, but if it's still not there, we ought to have a hard conversation that we're recognizing. And by the way, if I have that conversation and you still want to go forward, and I still think we're looking at, significant expenditures on my attorney's fees, say, and I don't care what the number is. I could give you a number. Listen, I was going to say $100,000 or more, but you know what? If someone's paying you $10,000, that's a lot of money, and so they have to have a reasonable expectation of what's going to happen. And so, obviously, if it's going to be a lot more, then I'd even be more careful. But even when it's 10 and you don't think you can prove their claim and they want to go forward, that might be a situation where you should be covering yourself with a letter and explaining what you see as the story, what you think is the likelihood, and while you'll undertake their claim with vigor, you are concerned that with the lack of information and actual proof of the claim, that they may ultimately not be successful at trial, despite how hard we intend to pursue relief. Because that's the other part of it. 10 to 1 person is someone else's 100. But when we're getting into really big figures, people are expecting a return on that investment. And if there's no return, and that was pretty clear from the outset, then they should have been told. And you better have proof that they were told, because that's the other thing. People forget what we tell them. You want that information here. There's a couple of interesting things going on here. And again, as we said the other day, Sellier has written it quite nicely. Plaintiff tries to convince him that Massachusetts law does not allow courts to enjoin a trespass. And so now again they say, well, that's just foolish. That's not the law at all. Obviously, Massachusetts law can enjoin a trespass. I don't know any jurisdiction where the court could not enjoin a trespass. So that just seems like kind of a silly point if he really was trying to argue that. That's just not what the law is. Let's talk a little bit about the status quo, because a lot of times in injunctive relief and request for injunctive relief and inequitable actions, we talk about maintaining the status quo during the pendency of the case. Plaintiff's argument is the injunction here altered the status quo, and what the status quo says, what it's supposed to be here, is the last uncontested status was preceded the pending controversy. It's not just where they were immediately before the litigation. That's not the status quo, because that's what he's arguing. Well, I occupied the station, I should get to keep both. What they're saying the status quo really means is the last uncontested position of the parties, which would mean you go back to your land, Monahan, whoever now gets to run the other station. But that's when that broke down is where we had the controversy. And so what status quo doesn't mean is where we were immediately before complaint was filed. It means the last uncontested status which preceded the pending controversy. And I think, frankly, that's the only place all semester we're going to see a definition of what the status quo is. Because oftentimes you'll see a lot of cases where they talk about a request for injunctive relief is made in order to maintain the status quo during the pendency of the litigation. And that seems fair, right? Let's not have any further changes. But what the status quo means is something other than what AUD wants it to be. Then he wanted to talk about a waiver. You read the language with respect to waiver under Massachusetts law. If you want to argue that Mobile waived it, you need a clear, decisive, and unequivocal conduct on the part of the authorized representative. And absent that, and he doesn't appear to have the proof of that, by the way, then the absent that, there can be no waiver established. Now, Mobile did in fact get the injunction, Roman numeral 3. It says, despite the fact that we find the preliminary injunction abundantly granted, appellant raises 3 parts to the procedure, right? We're talking about the procedure this week, how the injunction was granted and obtained. And he's got 3 points. 1, it was done without a hearing. 2, there's no contemporaneous findings under Rule 52 that we've talked about a few times. And 3, he says there's no bond. And we've read cases at this point. All 3 of these, from a legal standpoint, would seem to have legs to them. Again, different litigant, different circumstances. Any one of these might be enough for reversal. Again, go back to page 2 of the decision. It doesn't matter if the judge is sleeping with counsel for Mobile Oil Company. Nothing is going to change about this case because of his dirty hands here. So let's take a look at the lack of hearing. And I'm sure you used your dictionary to find out what askance in praxis meant. But Judge Selya said normally we would look askance at such a praxis that there was in fact no evidentiary hearing or oral argument on the granting of the motion. And as they say here, under our law in the First Circuit, as a general rule, where issues of fact are disputed, in an evidentiary hearing is in fact a highly desirable prelude to the granting of the injunctive relief. There appears to me to be sharp factual dispute about whether he talked to the regional people, whether he had obtained their approval, and whether therefore then he should be allowed to go forward with the resolution of the second mobile station. Again, I don't think there's any doubt the credibility of the witnesses here is in contention. And therefore, when we think about our earlier cases, it's almost clear that the request for an evidentiary hearing should have been granted. The court says, we don't care in this case, in essence. You know, that it's not an indispensable requirement when the court either allows or refuses to grant injunctive relief. Kind of interesting, because if we go to our other cases, I think we're going to find that almost always is mandated. But again, I think it's because of the way in which and I don't think, I am, for a certainty, I believe, it's because he got caught cheating, and once you're caught cheating, no one is going to do anything for you, nor should they. Preliminary injunction. Here in this case, what they say is the taking of evidence would serve little purpose because he doesn't stand a snowball's chance in hell of winning. Let's see, evidentiary. Then they go on and talk a little more about it, about probable outcomes and the like. But there's very good language in here, but it doesn't make a difference what they what they say about the hearing, because they're going to dispense with the need for it because they don't care about this guy whatsoever. Rule 52A, and we've talked about this. We did this 1 week where we know, and as it says in B, Rule 52A requires, in granting or denying or refusing interlocutory injunctions, the court shall set forth the findings of fact and conclusions of law. This is not discretionary. And we talked about the reason why, so that it's clear as to what reasoning, what basis the court had for its decision, and the reasoning that supports it. There were no contemporaneous findings of fact and conclusions of law. The judge here, for many, well, how much after the actual event was the memorandum done? Do you know?
A couple months.
Yeah, a couple months, right? If you were a couple months late in filing your brief, my guess is that the court would no longer accept it, and you might even find sanctions on your plate. Here, the court is concerned about overtaxed district courts struggling with their burgeoning caseloads, and what's a poor judge to do. The fact is, it also tells you, though, within this paragraph, here the court waited for some 2 months before delivering its findings. That's too long to be acceptable. The circumstances considered, and although it was an error, nothing turns on it in this case, so they really don't care, yet again, because of what happened here. By the way, that paragraph, though, does talk about, we tend to think of findings of fact and conclusions of law as in writing. I have seen judges orally from the bench just simply read their findings of fact and conclusions of law into the record, either taped or stenographically. And as it says in this paragraph here under 4, that is a perfectly acceptable way to do it as well. It doesn't have to be a written decision. It just has to be a formal decision that one can review, and orally is just fine as well. And I've seen them do that, and it's not a big deal actually. Then at least you can leave that day with your order, and so even the absence of required findings is going to make a difference. And then lastly, the bond, which we've talked about more than a few times. The bond is supposed to be there in the event the injunction is later found to be improvidently granted, in order to satisfy any costs the non-moving party, the party against whom the injunction is obtained, suffers as a result of having to comply with that injunctive relief. Now, Mobile thought it was a problem, because if you look at footnote 8, after they filed their opening brief in the court, Mobile then went back to the district court to request it, to ask them to fix a bond. Judge Nelson set the bond amount at $60,000. Mobile then posted $60,000, which is obviously a drop in the bucket for them. And so in essence, the court's saying, well, then it's moot because there's a bond there now anyway. So all three things, any one of them, could be enough to vacate the order, although the court does point out, and this is again what we talked about, you want a hearing, ask for it. You want a bond, demand it. And what they said here is that no one asked them to earlier set a bond. You didn't, and neither did Mobile. Mobile obviously wouldn't be asking to set a bond until the issue is raised here on appeal. But if he wants a bond, his first argument has to be made to the district court, and then he's got to try and make the argument as to what the amount of the bond should be. Having not done that, he shouldn't expect to be raising arguments for the first time on appeal. And again, even if he does, the court is not going to care what he says, because you can't win that argument when it hasn't been raised in the district court. So I think it's an interesting case. I think it's an interesting case and a result more because, not because of the law it establishes, but the rule it really establishes, which tells you, we've got to make sure that our clients are forthright and that we are careful that our reputation doesn't get sullied because we are not sufficiently careful, or we end up associating with people who will use us and the court system because they don't take it sufficiently serious, and your reputation becomes greatly tarnished in the process. And there are lawyers like that when you talk to other lawyers, you get a reputation quickly, and it's you don't want to be like that. I remember I had this problem with a lawyer in Quincy, and this is when I was up here, and I said, I got this unbelievable nutbag now, and Joe Devlin, who we never practiced law together. We practiced on some cases here together now, but we never practiced law when we were in Boston together. Never had cases together. And Quincy's a fairly large town. If you're not from that area, it's a city, and it's not that small. And I said, problem with the lawyer in Quincy, and he said, "Is this his name?" He goes, "Oh, who is it?" Bum, 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 bum. I said, "Yep." And that was odd to me because Quincy is not a small city. And for two lawyers to have virtually the same identical problem over a period of decades and views of the same person, that tells you that you will either rise and fall based on your conduct with other lawyers, and we have long memories and we don't forget. So I think it's interesting that we never found out who his lawyer was at the district court, but I would have liked to have known. Doctors Associates, back to subway problems again, versus Donald Stewart and the like. The franchisor files a petition to compel arbitration against franchisees. The district court orders arbitration, issues a PI barring them from prosecuting their suit against the franchisor in Illinois. And then the question is, where do we go from here? I did the bar exam boot camp last night. Those guys are going to be taking the bar exam next Tuesday in Connecticut, Wednesday, Thursday in Boston. And so what we give them is highlighted cases over the last year, and actually now it's over the last 3 or 4 years. You cannot believe how many cases there are that are important cases within the last 3 or 4 years where the court is interpreting these arbitration and choice of law, choice of forum provisions. We've talked about it in the past as well, especially the way business is conducted now. It's very important to have some certainty as to where the disputes can be resolved, and the court sees it that way. And they're in everything from the last series included discrimination claims in employment, student travel, field trips and the like, where they go to Mexico or God knows where and they're injured in process or when they're there. Whether the employee can agree, or anyone can agree to, even by way of the contract, limit the time period in which suits can be brought. So while normally a contract claim can have 6, can they agree, and in fact, frankly, that was a franchise agreement, can they agree to reduce the normal contract statute of limitations in Massachusetts from 6 to something less? Without the case, my gut would have said, no, I don't think you can alter the statutory time period for claims. And the court said, I think it's our SJC, said, Yeah, sure you can. And a couple of the other cases on arbitration, not forced, I keep using that phrase, on agreed arbitration by way of contracts and the like, is that while the courts will favor it, it's got to be clear that that's what the parties intended. Because sometimes we'll have a choice of forum clause that, this was Judge Agnes's decision in the last couple of years, if any parties have any dispute, they may file that claim in the Massachusetts Superior Court. Now that's not exclusive then, right? That means we can file the claim there, but we don't have to file the claim there. There are these decisions where the corporation signs, but if Kelly is my employee, doesn't mean she's bound to that arbitration provision within that forum. And so what we have to do is recognize that, in all likelihood, the bigger battle has been lost. These arbitration agreements are going to be enforced. Now the question, like any other contract, is what was the party's intent and who's bound by the terms of those agreements. And so that's where we're seeing shakeout now. This is an interesting one because we've got some contractual personal jurisdiction arguments. We've got another breakdown in our franchise provisions. And the franchisee here, there's these not unusual cross default provisions and the like, but it does sound like the franchisee was getting, again, I always feel bad for the little guy anyway, the short end of the stick here. And what happened is the best best defense is good offense. They filed their suit in Illinois against Doctors Associates, Subway, seeking declaratory judgment that the arbitration clause was unenforceable, damages for violations of the Franchise Disclosure Act, breach of the covenant of good faith and fair dealing, the ones we saw before and the like, Deceptive Business Practices Act under Illinois, not Mass 93A, but most states have some equivalent form of statute now. And then what DAI did in response, obviously, is seek to compel arbitration, which will remove any opportunity to have a case heard by a judge or a jury, and ask for a PI, barring them from pursuing their action in court because of the contractual provisions they had. And so what we've got are dueling court cases at some point, as you can see here. And that, again, in business litigation, this is not that uncommon, that we're fighting one front one place and one front the other place, and we're trying to scurry as quickly as we can to gain the higher ground, with the hope that we can keep it in a form that we think is most advantageous. And it happens a lot, but think about how expensive that must be, in essence fighting a two-front battle at pretty significant speed right after the case has been filed. So you hope your parties have some resources and the like. But this case doesn't turn on all the intricacies of the dueling court cases as much as it turns on the question of the bond. And the district court did not require Doctors Associates to post the injunction bond when they granted them the injunction. And as you can see, as it talked about here, there's a bunch of different pieces of litigation concerning Subway and Doctors Associates. This was back in 1996. I assume they run a better shop these days. There's some question about personal jurisdiction and venue and the like. It says, can a party contract away questions of personal jurisdiction? Why not, right?
That's what they did this, right?
Yeah, it's not uncommon actually at all. A lot of business agreements. Again, we want to have some established place or minimum choice of law where if there's a dispute, we're not fighting about whether we're in the right place. Questions of personal jurisdiction can take months, maybe longer to resolve. And why not have some level of certainty to it again, you know, frankly, you can waive, in my opinion, much more important constitutional rights. Why shouldn't you be able to waive your right on the question of personal jurisdiction? When the party agrees to arbitrate in a state, and as you see here, it makes reference to this Federal Arbitration Act, which in the Federal Arbitration Act and the cases that are interpreted under it highly favor the arbitration of disputes. You would think they would say, no, we highly favor the jury trial. And neither the statute or the case law says that at all. They say they want to keep the stuff out of our courts, God bless them, and let them do it. And so there's a real strong preference for enforceability of these provisions. And so they can in fact do it. You know, if you don't like it, you shouldn't have agreed to it at the outset. And then they ask about the essential elements of an action in fraud. And I still think this is important, because a lot of times we have clients come in and say, well, I signed it, but it was because of fraud. I signed the release, as one of these cases that I gave out to the students last night. It says, I only signed the settlement because they fraudulently induced me to do it based on promises that now aren't contained in the settlement, blah, 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 blah. You hear it a lot. Because it may be a means of avoiding the consequences of a bad decision. But if you want to plead fraud, if you look at Note 3 here, not Note 3, Arabic 3, it tells you what fraud you'd have to prove for fraud. That a false representation was made as a statement of fact, right? Not just puffing. That it was untrue and known to be untrue by the party who made it. That it was made to induce the other party to act on it, and that the other party did act on it to its injury. That is basically what you have to show in order to prove a common law action of fraud. And if you cannot establish that, then you likely do not have a fraud claim. The other part of fraud is, in a civil suit, is you generally have to plead fraud in your complaint with greater specificity than you would otherwise, because that's the requirement of pleading. You can't just simply make an allegation of fraud without providing specific facts that support it. Let's see. I want to see if there's anything else that I think important.
I have a question.
Yeah. By the way, it does make reference, and we've never talked about that. Well, we're not here. These provisions where you have to arbitrate, or you have to even, your parties agree to mediate. This is an expense, and it's an expense over and above the cost of litigation. Now, obviously, if you arbitrate and are able to not resolve it, because you're going to have an adjudicated result of some sort, but it's going to be a lot faster than a court decision as a general matter, and more cost effective. That's all well and good, but someone's going to pay $5,000 in all likelihood for the mediation, and as a general matter, the rule is it's split between the parties. That's another $2,500 that your client's going to have to come up with. I don't think in this one it's going to be a problem. We've got Subway, and we've got a franchisee that should have some money left. But for smaller business entities or individuals, after having paid your fee to come up with a sizable deposit like this for an arbitration or even mediation, we preach to you guys to want to encourage you to resolve disputes outside of court. But if we're going to a mediator for a half a day or a day, we could be talking about thousands of dollars. And again, that cost is generally split, but that's something that we can negotiate. I've done a mediation recently where I said, I'll be glad to go, but we're not going to pay a dime. I don't think you've been serious about it yet. I'm not going to go waste my time and my client's money to go sit with someone. If you want to mediate it, I'll be glad to spend the day. But it's going to be your cost for the mediator. We're not paying anything. Frankly, to me, and I really think I don't know whether it helped in this case, but I think it was important in this case for them to make that better show of faith than they had made prior to that, because they were offering, frankly, they were offering peanuts the morning we started the mediation. But I think knowing they had invested and that mediator wanted a $5,000 retainer for the day, knowing that they had invested $5,000 in the mediator plus the lawyers that they were having attended, I thought that at least expressed that at least showed more good faith than I had seen prior to that time. But I wasn't going to spend my money, and the client didn't have the money to be throwing good money after bad if they really weren't serious. Because I frankly, a lot of times I don't think, if you want to be reasonable, we should be able to negotiate without a third party needing to try and help us get there if people are reasonable. That's probably a nice thought, but I'll tell you, I've seen a lot of times where they are very helpful. And it's not necessarily helpful to try and get me to be reasonable, although obviously I could be more reasonable at times. I think sometimes it's necessary for the other side to get a sort of reality check and say, you know, his claim's not bad. He's got a lot of evidence. He's not going to settle for peanuts. And so maybe they need to have someone seasoned tell them that. And okay, if you do, but it would seem to me, and it does seem to me, that two experienced lawyers understanding each other's cases and with being able to properly educate and inform their clients shouldn't need the services of a third party. Even with that said, I've had a lot of cases where I think that's been close to the circumstance, and without that mediator, it never would have gotten done. Never. Would have gone to trial. That I don't know whether it's the client sometimes, and that's the purpose. That is the beauty of a mediation too, right? It's not, they've heard it from me, now they have to hear it from the mediator saying, you know, listen, this is a pretty fair offer. Or to the other side is, that's just not going to do that, and it's not reasonable. And so sometimes it's the other side. I like when the mediation is part of the court process. The federal court has free mediation, right? They'll use a magistrate judge or another judge from another judge in the court who's not sitting on your case. Costs you nothing. What the hell? That's great. And I think especially from a client standpoint, to have a judge mediate the case, they at least feel like they've been heard by a judge, and that person somehow has greater wisdom than anyone else because they are a judge. And I think lay people think like that. And that's great. But there are good mediator judges, and there are bad ones. And so that can happen as well. And the same thing with arbitrators. This is, you know, when we pick an arbitrator, when we pick a mediator, that you want to know what their background is. Okay, we agree to go to AAA, AAA arbitration. There's a bunch of mediators there. Now we've got to figure out, and what does the process say in the contract as to how the mediator is selected? A lot of times, you select one, I'll select one, those two will select a third, we'll go to a panel of three. Three means more money though, right? So, but that at least gives us a better feeling of that it'll be fair. Because if it's only one person, and I've tried it before one, and that's, you know, it's like you're trying it before a judge. You hope you got a good one. You hope you got a good case. You hope you got one that'll understand it. So at the end of the day, the arbitration provision is, in fact, going to be upheld here. They want to argue again about this whole notion of the hearing on personal jurisdiction, and all of these arguments are going to go out the window, even why the case is here, bond question again. And this is the one I sort of gave you a prelude to the other day. The district court didn't require an injunction bond. The rule seems to require, by its very language, an injunction bond. And this is what they do with it if you look at the last page of the decision. It says Federal Rule 65C says that the court, the bond shall issue, no injunction shall issue, except upon the giving of security by the applicant in such sum as the court deems proper. And now they are going to interpret in such sum as the court deems proper as providing so much discretion to the court that in such sum can be zero. In fact, that's the way they interpret it, is that the discretion is so broad that at least in your Second Circuit, that can be considered to mean no bond. A lot of times in Mass, what the bond is really a nominal bond, $50. At least there's something, but even a $50 bond isn't going to do anything. So a lot of times the court will set a nominal bond because it has so much discretion. And I guess the argument is if it could be for a nominal amount, why not just forget that foolishness and make it anything? Now, last one is Equifax hits. And I want to ask you about the fairness of what was done here as well. So Kelly works for me for a number of years down in Georgia selling shoes. And you know what? I decided I'm going to fire her. So I'm going to bring her to Boston to chastise her. And I'm going to fire her. And then I'm going to say that when she was, that her coming to Boston for her reprimand and termination is enough to create personal jurisdiction, because I made her come here. And then bring suit against Kelly for injunctive relief and damages, because she was a faithless agent. Doesn't it seem something grossly unfair about creating the basis for personal jurisdiction?
Sounds like the Burnham case.
Sounds like Burnham, except Burnham, fair enough. It sounds like what our discussion was in Burnham, where Burnham was more voluntary than this, though, wasn't he? And Burnham at least came for a little business, then went and saw the kids. But for me telling Kelly she had to come to Boston, she wouldn't have likely been there. How voluntary is that? Or at the end of the day, it's still voluntary. Because she wants to get paid, she's got to come. But I've got ulterior motives. That can count as contacts, they say. Right? For the purposes of personal jurisdiction, the constitutional touchstone remains whether the defendant purposely established minimum contacts in the forum state, Burger King. Did she?
There can't be any fraud in the inducement, but then the burden might be on her to prove that when you invited her up, you had ulterior motives. She'd have to prove that, I guess.
She was physically in Boston.
She was.
Not through a normal course of business, but
Well, not through normal. I mean, she's my employee.
right, she'd have to show it wasn't a normal course of business and that you induced her fraudulently.
The reprimand was more of a pretext.
Yeah.
Would that matter? I mean, she's still my employee. Huh?
I said, call me. Don't have me fly all the way up here to fire me.
Well, but I got to have you fly up here because I might not have contacts otherwise. No, right? I mean, this is... But listen, the case is what it is. Because if you were advising a corporation, this is the way to do it. Because then I get to sue here. She's not going to be running back and forth to Georgia to worry about to dealing with the injunction. She's going to have to roll over and play dead. The case talks about, footnote 1, this is a case of specific jurisdiction because the litigation arises out of or is related to defendant's contacts with his Kansas employer. That's the Helicopteros case. It is, right? She's an employee of the Kansas company. She was paid by us. We brought her here for the reprimand. We then terminated her, and now we want to sue her in order to make sure that we can obtain injunctive relief over her, and we want to do it in Kansas, where our company is. And other than attend a training session very early on, she's never been to Kansas before. Only summoned here for The reprimand. Defendant's primary argument for lack of jurisdiction, Arabic 3, is that none of his contacts with Kansas were purposeful because they were required by his employer. But when the forum contacts are a natural result of a contractual relationship, which they are, right?
Sure.
It indicates purposeful affiliation with the forum through an interstate contractual relationship, and then they use the famous Burger King case. And then it goes on to say, and to be, once it has been established that the defendant has established those, purposely established those minimum contacts, then all we need to know is whether the exercise of personal jurisdiction comports with traditional notions of fair play and substantial justice.
Right, so if they already had the complaint summons or whatever they served notice with, and they already had it prepared beforehand,
Did they serve her in
I don't
Kansas
think so.
when she was here?
But they would have to, right?
No, no, I don't think they did.
The action or incidents occurred there, okay?
Yeah, the argument is she's created the contacts. Once she has, I don't have to serve her here. I think Ash was saying from the Burnham case, I do think they would, if their argument was she's here, personally served, I think they might have a harder argument making the Burnham argument that she's voluntarily present or that it wasn't pretextual to bring her here to serve her in hand. And it might be the exception, really, to the Burnham rule that, oh, well, wait a minute, this just doesn't smell right. I think here they're just simply trying to use it as an additional contact, and by additional, that's being pretty generous because there really isn't a lot of contacts in this case at all. But I just think it's an interesting example of it. The likelihood is these days, if you're a contracted employee, you've already got provisions in your agreement that are going to deal with this because the court enforces these pretty regularly. Lastly, again, the case is about the bond and the like, Roman numeral 3. Defendant contends that the district court abused its discretion in requiring Equifax to post only $10,000 in security under Rule 65. The rule requires a bond to secure damages from a wrongful injunction only in such sum as the court deems proper. And here's the big key, again, is the end of Roman numeral 3. The defendant presented no evidence to the extent to which he would be harmed by an injunction. If you want an injunction bond and you want a sufficient amount, you've got to be prepared. You, as the non-moving party's lawyer, have to be prepared to be able to offer evidence as to what your damages will be. You know, frankly, it wouldn't seem like in a situation like this that well, how long is he going to be enjoined? What was he making at this job? One times the other gives us, at the minimum, at least one portion of what he would be out and the requisite bond amount at the minimum. This seems like a pretty easy one that should have been made, but his attorney never made the argument. And so you've got to make the argument. And you've got to be prepared to argue what that bond amount should be. And on the face of it, this wouldn't have seemed like a very difficult bond argument at all, but not having made it, don't complain on appeal that there was no bond because your first argument has to be fashioned and made in the district court if you're going to argue the issue on appeal. Questions on the case? I think there's some interesting issues with it, and I think the bond, again, in looking at the bond amounts this week, I think there's a couple things that become readily apparent. You want a bond, you've got to ask for it. You want a bond of any amount. It's not just asking, but it's then presenting evidence about what your actual losses will be during the time period in which you're enjoined. And if you want a hearing on the bond and the like, then you got to request it as well. And absent that, don't complain later on. And you know, the fact is, this poor guy may well be able to establish later on that the injunction was improper, but at that point, $10,000 isn't likely to compensate him for whatever his losses would be in that period. because he's likely got some significant losses, being unable to work at least for some period of time. Questions? Yep.
So, excuse me, so if the injunction proves to be improper, his only remedy is the bond that's been set, he can't counter?
No, because he doesn't, you see, and this is, I think we've got a couple of cases later down the road. And here's the interesting thing about it, if you think about it. It's not really an abusive process, right? It's not malicious prosecution or anything along those lines. I had a case that was sufficiently meritorious that the judge felt I should get injunctive relief. Well, as it turns out, the judge was wrong. It's been established on appeal. Well, arguably, not arguably, that doesn't mean you have malicious prosecution. The judge agreed with me. And the fact is that it at least was believed to be sufficiently meritorious. Frankly, to some extent, you're lucky that there is a bond amount there that you can now go after it. But your damages are generally going to be limited by the amount of the bond, and that's why the moving party wants to keep it as low or none at all, in order to not have that available should it later be determined that the injunction was improper. At the same point, that's why you need to start to argue that you need a significantly higher bond, because maybe the moving party can't post it, and B, if they can post it, at least you have some sureties for your damages should it later be determined that no injunction should have issued. But just because you're enjoined doesn't mean that the moving party was incorrect in attempting to get you enjoined. Remember how much discretion there is there with respect to the granting of injunctive relief. Anything else? Yep.
Question from the last case on arbitration. The arbitration is versus mediation. Mediation isn't final, whereas arbitration is. And I don't know if this is back on the Anthony's Pier 4 case, but isn't mediation more popular because of that, or no?
Mediation is generally more popular because we are still empowered to resolve our own cases. And if we don't like what's going on, we get up and walk. If we don't like the amount, we get up and walk. At the end of the day, if I choose or the client chooses to accept or reject whatever we're at the end of the day, that's they are free to do so, and we walk away. In an arbitrated decision, it is a judgment, just like a judge would make. And you might be happy, you might be unhappy, but at the end of the day, that case is over. You can appeal the arbitration to court, but generally the arbitrator's decision is not going to be vacated unless it's found that the arbitrator's decision was arbitrary or capricious. That's a pretty high standard, not just wrong, arbitrary or capricious. In essence, no basis to find as the arbitrator did. That's a tough standard. What I would say that I think most people favor mediation because it doesn't eliminate their right to go to court and the like, and have a jury hear their case if that's what they want. However, with that said, the prevalence of these arbitration clauses within probably virtually every agreement you're entering into these days, certainly online, and perhaps elsewhere, I might even see those as I'd see those as more favored. I don't think they're more popular. That's the language I would use. Mediation, what the hell? If it works, great. If it doesn't, great. Right? I haven't lost my right. Arbitration, I may have lost the ability to walk down the street and go to court, and I have likely lost my ability to have a jury of my peers hear that case. And so it eliminates many options. With that said, it's a lot faster. It's a lot faster because the whole process of discovery isn't the same. The rules of evidence aren't the same. So there are benefits to it, but the same protections we might find some comfort in court are not going to be there. Okay? See you guys next time.